for a petition of the Borough of Downingtown, appeals of J.Lo and Associates, Kim Manufacturing Company, and the Friends of Kardon Park, Mr. Robert Byer, Mr. H. Fitton McHugh, Mr. Samuel Stretch.
Good morning. This case concerns several parcels of land that the Borough of Downingtown acquired by purchase or condemnation and that were dedicated and used as a public park. The borough sought to sell some of the land for residential housing and commercial development, as well as grant temporary and permanent easements over portions of the property. Several residents of the borough sought to enjoin these actions, claiming that a number of statutory enactments, including the Donated or Dedicated Property Act, the Eminent Domain Code, and the Project 70 Land Acquisition and Borrowing Act, are implicated by the borough's plans. The present dispute primarily centers on which of these statutes, if any, controls or restricts the borough's authority to dispose of these properties. So with that, you may commence arguing, Mr. Byrne. Thank you.
Thank you, Mr. Chief Justice, and may it please the court. I'm Robert Byer, and I represent the designated appellants J.Lo and Associates Incorporated and Progressive Housing Ventures LLC. The Borough of Downingtown and the Council of Borough of Downingtown also are designated appellants in these cross appeals. They're represented by the borough solicitor, Mr. Patrick McKenna, who is with me. That Mr. McKenna has authorized me to speak on behalf of his clients this morning as well, that he is available to answer any questions that the court might have with respect to the borough. In deciding that court approval was required for the borough to sell property that it had acquired by condemnation, the Commonwealth Court departed from express statutory text and misapplied this court's holding in Erie Gulf, as well as disregarded findings of fact by the trial court. Section 6 of the Donated or Dedicated Properties Act and the later enacted Section 310 of the Pennsylvania Eminent Domain Code dovetail perfectly. Section 310 provides a condemnor, in this case the borough, with the ability to sell property that it had acquired by condemnation after 21 years if it has abandoned the purpose for the property, for the use of the property. Section 6 of the Donated or Dedicated Properties Act provides that the act would not limit or restrict the rights of a municipality under condemnation, that it acquires by condemnation. In reaching a holding to the contrary, the Commonwealth Court relied upon language in this court's decision in Erie Gulf. Erie Gulf dealt with purchased property, and I think it's very significant that the property in Erie Gulf had been purchased in 1925, long before the 1959 enactment of the Donated or Dedicated Properties Act, which modified the public trust doctrine in Pennsylvania. The property in Erie Gulf, in other words, was subject to the full operation of the public trust doctrine at the time that that property had been acquired by Erie. And this court had to engage in a construction of Section 6 of the Donated and Dedicated Properties Act, dealing with that particular situation so as not to arrive at the paradoxical situation where the property is taken out of the purview of the DDPA and at the same time then made subject to the public trust doctrine, which would be more restrictive. That situation does not apply in this case for two reasons. First, the property had been acquired by condemnation, and second, it was acquired after the enactment of the Donated or Dedicated Properties Act. So if we look at the law as it existed at the time of the acquisition, these two sections of two statutes that must be read in paramateria dovetail perfectly.
Mr. Byer, I'm intrigued with the idea that when Erie Golf Course was purchased by the municipality, public trust was the law and has some institutional perpetuation. But what I wanted to ask you about is what's bothersome with Erie Golf. If you look at 3386, after it provides its substance, it says by purchase or condemnation. It obviously does not distinguish in any way, shape, form between the two. So how do you, and when I understand the argument, there's a statute for condemnation, there's not for purchase, but that's not what 3386 says. And I think the Gideon's not of this case is what in the world does 3386 mean?
Well, 3386, as applied to condemned property, works perfectly in conjunction with the eminent domain code because of the statutory authorization on the part of a condemnor to dispose of property after abandoning purpose after 21 years had passed. Now, with respect to 3386, the language of 3386 as written by the General Assembly supports our position with respect to condemned property and would have supported the city's position with respect to purchased property in the Erie Golf case, but for the need for the court to engage in a very limited construction of that statute to save the parties from what was termed in the Chief Justice's opinion in that case, a paradox that would be created. That paradox is not created here, and where the court is engaged in a limited construction of a portion of a section of a statute in order to avoid an absurd result, but that would not apply with respect to the rest of that statute as enacted by the General Assembly, then this court's function is to apply the statute as written in accordance with its legislative intent. And there is no need for construction and no need to resort to common law doctrines that are inconsistent with what the legislature had provided and what the legislature is deemed to have intended to displace.
So as you read Erie Golf, for property that was purchased after 1959,
well,
Erie Golf would not apply.
That is an issue that's not before the court right now, but it is a way of looking at Erie Golf.
Well, under your analysis, that's what it would have to be, because your analysis is it was a very limited construct.
My analysis is that it was a limited construct. This court, even in reaching the issue in this case with respect to the application of Section 6 as regards property that had been acquired by condemnation, would not have to engage in that limitation of Erie Golf.
But for that case, your case is clear. The
That is
act
correct,
doesn't
Your Honor.
apply to condemned property.
That is
The
correct.
Eminent Domain Act would apply.
The only thing that gets in the way is Erie Golf. That was the only thing that the Commonwealth Court relied on. That was the only thing that the trial court relied on. And it reminds me of Professor Llewellyn's adage in the Bramble Bush, that where stops the reason for the rule, there stops the rule. And in this case, the reason for the rule of Erie...
It antedated him. He just put it in English.
He just put it into English. That's correct. But it's the one that I learned. So, but that would be the disposition with respect to condemned property. The Commonwealth Court reached an alternative holding under the eminent domain code dealing with this issue of abandonment. And in so holding, the Commonwealth Court again disregarded the language of the code with respect to abandonment of purpose as distinct from abandonment of use. The Commonwealth Court, if taken to its logical conclusion, would have required that while the borough is attempting to sell the property that it had the right to sell under the eminent domain code, that it was required to bar all public access, put up barricades, police it, arrest people for trespassing. Instead, all that the statute required was that the purpose be abandoned. That's accomplished under the case law by expressing an intent to do so and external acts that are consistent with that. In this case, the borough has long expressed the intent to sell this property. The record is replete with it. It has engaged in external acts by, again, trying to sell, including this litigation. And the trial court, as a matter of fact-finding, determined that the requirements of an abandonment of purpose had been met. That fact-finding is supported by substantial evidence, and the Commonwealth Court erred in its alternative holding in disregarding that.
Let me drag you back for a second to 3386, since that's the clog in my attempting to understand this. Could it mean that, to the extent, was the legislature saying, to the extent property is not donated or dedicated, which can occur subsequently to its acquisition, that nothing in this act is going to say that the DDPA controls that type of property. But when you take what you've acquired, whether you've acquired it by eminent domain, by Project 70, or you just outright purchased it, and you as Downingtown go through an affirmative act of donation or dedication, that takes it out of 1386 and puts it into the other provisions of the act.
We think that would, that type of construction or interpretation of the statute would lead to into the absurdity principle of the Statutory Construction Act, because anytime a municipality acquires property by condemnation, it is required to state the purpose of that condemnation, the purpose for the acquisition. It has to be a public purpose. That must be in the declaration of taking. That's required by the eminent domain code, and that was complied with here. So you immediately have a dedication, and what the Donated or Dedicated Properties Act makes clear are two things. First, in an earlier section dealing with its scope, it says that it applies regardless of whether there was a formal acceptance. So when you condemn property for acquisition by a municipality, you have immediately dedicated it. It's instantaneous, and no formal acceptance is required at that point. The argument has been made, well, the public hadn't used it as a park. The borough, it was intended to be used as this open space and parkland. That was clear from the condemnation. That was the purpose of it. So you have the dedication. So to say that Section 6 can then be read in that way, 3386 is Section 6 of the official text of the Act, it would have the statute contradicting itself. And we don't think that's what the General Assembly intended. Instead,
Explain to me, again, I'm very interested in the answer. How does the statute contradict itself in those terms?
Because all condemned property has been dedicated. So it then makes the provision of Section 6 that it would not apply to rights acquired through condemnation. It would make that meaningless. That would be the contradiction.
Mr. Byer, I'm just trying to follow you. Is the declaration of purpose that is required under the eminent domain code in a condemnation the same as a dedication?
We believe that it is, in the sense that it's an expression of intent to use this property for a public purpose that is a dedication to that public purpose under the case law and the definition of dedication.
Thank you.
That takes us to the issue with respect to the Project 70 Act that is raised in the cross appeal. And under the Project 70 Act, Section 20B of the statute expressly confers on the General Assembly the power to authorize the sale of property that had been acquired under the Project 70 Act. This applies to the parcels, in this case, the northern parcels that were acquired by Project 70 funds. The General Assembly, in two statutes, Act 29 of 1999, that's included in Volume 2 of the reproduced record in this case on page 1159A, and in Act 162 of 2012, Section 6 of that Act, which is included at pages 2982 through 2983A in volume 4 of the reproduced record, those statutes expressly release these northern parcels from the restrictions of the Project 70 Act, and those statutes each refer to Section 20B. Each statute says that it is enacted in accordance with Section 20B of the Project 70 Act. That is the authority on the part of the General Assembly to sail. Now, the Commonwealth Court and the trial court correctly held that that statutory authorization and that has been implemented by additional statutes passed by the General Assembly with respect to this specific property was all that was required to authorize that sale, and that the borough was not required to obtain additional approval under the Donated or Dedicated Properties Act. If this court were to accept the argument in opposition and hold otherwise, it would set up a conflict, a needless conflict between the judiciary and the General Assembly, where the General Assembly has acted for the specific purpose of authorizing the sale, and not only authorizing the sale, but in each of these statutes, the 1999 Act and the 2012 Act dealing with these properties, expressly directing how the proceeds of those sales are to be used for new public purposes or the acquisition of additional property that will be impressed with Project 70 restrictions, for a court to then say, under the DDPA, no, you may not do what the General Assembly has just authorized, sets up a constitutional conflict. The General Assembly has made the rules in this area. It's entitled to change those rules. Project 70 came again after the Donated or Dedicated Properties Act. The Project 70 statute was passed in 1964 pursuant to specific authority in the Pennsylvania Constitution.
Can I stop you there? I just have one question right on that point. I understand your rationale as to the 1999 Act and the 2012 Act lifting the restrictions from Project 70 on this parcel of land, but what part of your argument supports the fact that that also alleviates that parcels from going through the DDPA and passing through the Orphans Court before you can go to sale?
Because the General Assembly, in enacting the later statute, is presumed to have been aware of the DDPA. It did not require for DDPA authorization with respect to property under that act. It provided only for authorization by the General Assembly. The General Assembly, in other words, sits in the same place as the court under the DDPA.
But there's nothing specifically written in that act. That's merely your interpretation of it. There's no specific language that says, by pursuant to the 1999 Act or the 2012 Act, that you can bypass the DDPA.
That would be a conclusion that we reach by reading these statutes in pari materia, because you have to read them as if it's one enactment. And so you have this specific subset of public property. And again, property under Project 70 would be property that would be covered by the DDPA, but for the specific provisions in Project 70. Reading these together and recognizing that Project 70 was a later enactment and a more specific enactment versus the general provisions of the DDPA, that is, we suggest the proper construction under the Pennsylvania Statutory Construction Act.
Mr. Byer, the opposing party makes the argument that in addition to the Project 70 funds, there was a substantial expenditure of other public monies in the effort to improve this particular parcel. And as I understand their argument, it goes something like, and it is because of that other substantial public investment in this property that the sale has to go through the Orphans Court pursuant to the other act. What is your response to that?
There is nothing in the Project 70 Act that provides that the Project 70 Act applies only where it is the sole source of funding. The General Assembly anticipated that Project 70 Act funding would be partial in many instances, but nevertheless it provides that the entire property so acquired is impressed with the Project 70 restrictions. So, for example, one couldn't argue the converse, that because public funding was used for a portion of the property, that portion should be deemed not to be subject to the Project 70 restrictions that exist until the General Assembly changes it. It's simply not possible in any workable way to make that division.
Well, does the Project 70 protocol protect that other public investment insofar as the proceeds of the sale are imprinted with the Project 70 direction that the proceeds will go for another public purpose?
The General Assembly has done so here in these two specific instances without distinguishing between what money was provided by whom.
So it is protected.
It is protected, and the General Assembly has even protected to the point of, I believe it's the, I forget if it was the 2012 release or the 1999 release, but one of those two statutes even requires that a minimum of 20 acres of property be held aside as parkland. So the General Assembly was cognizant of what it was doing. It acted in accordance with what it deemed to be the public policy and public interest. And this is an area, municipal control of land use, that where the General Assembly is the rulemaker. There is no common law doctrine at this point that would authorize the court to engage in any gap filling, if indeed there were any gaps to fill.
But there is none in this case.
There is none in this case.
As a result of the restrictions that are part of the authorizing legislation.
That is correct, Justice Donahue. The only remaining issue in this case, and I'll just be brief on this, is the question of the easement that the trial court approved. There is nothing in the Donated or Dedicated Properties Act. And this easement is with respect to property that is going to remain in the ownership of the borough. It's called the Mizell Tract, and the easement is to facilitate the development that the borough has approved with respect to these other properties that are at issue here. And the trial court engaged in fact-finding and stated that the grant of these easements would in no way interfere with the continued use of that tract for public purposes. That fact-finding, again, is supported by evidence. The trial judge relied upon two expert witnesses who testified, and that fact-finding, again, is controlling. The trial court and the Commonwealth Court got that issue correct. The only other issue that I will mention briefly, since we don't allow rebuttal, is that the deemed appellees have raised the issue of Article 1, Section 27 of the Environmental Rights Amendment of the Pennsylvania Constitution. As we point out on page 18 of our second brief in the cross appeals, that question is not a question on which this court has granted review. So unless anybody wants to hear about that, I will sit down. Thank you.
Thank you.
Good morning. May it please the court. My name is Finton McHugh. I represent Kim Manufacturing Company and Stewart Hall LP. With me today is Sam Stretton. He represents the Friends of Kardon Park parties, and I would like to reserve about a third of my argument for Sam, who's going to make some additional points. And however, I would note at the outset that we will avoid all redundancies. Your Honors, this is a...
That's quite a promise.
Sam has to help me on that.
Well, I'm a little suspect if you say 2/3 of your argument, you're turning over to him. You're arguing as an appellee, he's arguing as an appellee, so there shouldn't be any, but go ahead.
I don't know, Mr. Stretton, if Justice Todd is saying it's quite a promise because it's you, or more generally, I don't know.
No comment.
Thank you. It's a privilege to be in this magnificent courtroom. This is a park sale case, and it was born under the DDPA. I would respectfully submit that it should end under the DDPA. The borough filed its petition in the Orphans Court in 2009 under the DDPA. There was 5 days of trial under the DDPA. We argued, all of us argued under the DDPA. The trial court issued a 24-page opinion applying all the facts of this case under the DDPA and concluding that the borough did not meet its burden of proof under the DDPA. Now, after that decision, the Commonwealth Court in 2012 went in another direction. It raised new issues. It sua sponte raised the Project 70 Act after argument. It was never even raised. And it also raised the eminent domain code and remanded back to the trial court, and we have this new opinion. But as with all other park sale cases, this case is no different. All the other park sale cases deal with the DDPA. They don't deal with the Project 70 Act trumping the DDPA. They don't deal with the eminent domain code trumping the DDPA. They deal with the DDPA. And I would admit, though, when I have my nose buried for hours on end in these briefs, I can get a little dizzy and wonder, what did the statute over here mean? What did the legislature mean over here? But I always come back to the same basic question. What are we talking about here? We're talking about the disposition of public parkland. And the preamble of the DDPA says, specifically, it's regulating the disposition of public parks. So it's specifically designed for that purpose. So on the one hand, we have the DDPA that specifically is designed to protect, to regulate the disposition of public parks. On the other hand, we have a rather obscure eminent domain code provision that is designed to protect reversionary interests of condemnees when a condemnation project has been abandoned. On the same hand, we also have, yes?
Your argument would be, I'm going to return to the same recurrent theme, which is what bothers me in the case quite obviously, which is your argument's perfect and it's good, except for the plain language of 3386, saying nothing in this act shall control, limit property acquired by purchase or condemnation. And of course, Erie Golf Course saying, well, the plain language doesn't mean what it says when it comes to purchase. So how do you get around that?
Yes, and as Justice Saylor pointed out in the unanimous Erie decision, it's an ambiguous section, and there would be a lot of ink and a lot of money saved if they had only put what Justice Baer mentioned, some language in there that says for properties that haven't been donated or dedicated. If that language was in there, there wouldn't be any dispute. So it is ambiguous. But as
if they had not passed 3386, you'd have a stronger case. So.
Correct. But the rest of the Donator Dedicated Property Act is very clear that it applies to public trust properties that have been dedicated as parks. And those terms, public trust terms and parks, those terms are threaded throughout the DDPA. And it's only when you get to Section 6, it's a head scratcher. It really is. Because it seems to be an exception that completely swallows the rule, because that's really how municipalities acquire all properties. It's condemnation or purchase. It's very rare that you have a donated property. But as Justice Saylor wrote in Erie, it's ambiguous, but he looked at the facial applicability of the act. And otherwise, the act is pretty clear. I can see that the definitions could be a little more artfully drafted, and they would help to avoid some of the ambiguities here. But really, if you look at the act in toto, we're talking about an act that regulates parks, and that's what we're dealing with here today. I know that the appellants are relying on Section 6, but again, that exclusion was rejected. That argument was rejected in Erie. The trial court here followed Erie and said that it made no sense to exclude the golf course because really the dedication is what is the triggering fact of this park. It's a dedicated public park, and that's what triggers the DDPA. The Commonwealth Court followed that reasoning and said it would be illogical to hold anything different because there was a wealth of facts about almost 40 years of dedication here. But appellants are trying to basically, what's going on here is appellants are basically trying to recast the Erie decision as if it meant that the Erie decision was really about maximizing municipal discretion. That's not what Erie said, though. Erie said the opposite. It said that the municipality only has the right to apply to the Orphans Court, which is all we're asking for today. We're not saying they can't do this. We're saying that they have to apply to Orphans Court, and that the Orphans Court has full discretion under the DDPA, under Section 4.
How do you respond to your opposing counsel's pointing out to us that as to these two properties acquired by eminent domain, that you have to put the purpose in the eminent domain application?
Well, Your Honor, Justice Baer,
does that mean that's the dedication and therefore they're stuck forever? The municipality is stuck forever, that into perpetuity they can never do anything with these?
that's the crossroads of this case, really. What the appellants are arguing on the condemnation issue, as well as the public Project 70 Act issue, they're hiding the 40 years of dedication. They're saying that the condemnation, the original condemnation, that's the dedication. And therefore, we can just disregard this other 40 years over here. And they're also saying for the Project 70 Act argument, that the Project 70 Act, the actual deed restrictions themselves are the dedication. And that's where the Commonwealth Court on that issue went astray and followed their argument that, and the Commonwealth Court actually said that it voids, that the removal of those restrictions voids the dedication. And it actually used the terms and or to equate the restrictions and the dedication. So on the condemnation issue, Justice Baer, it's the dedication is not the original.
As you answer that, I think that the keystone again, and my last point, because this is something we're going to have to unravel, is that if you put the dedication, if I understand your opposing counsel's argument, if you put the dedication into the eminent domain code, then you rely on the eminent domain code for that process. And how do you therefore abandon the eminent domain code on the other end when you want to sell it?
Your Honor, I understand that's their argument, but we're talking about more than just the dedication is not just what was written in the notice of condemnation back in 1974, 1978, and it's more than what was written in the Project 70 Act deed restriction in 1968. Those are indicia of dedication. What the Commonwealth Court erred on the Project 70 Act and what appellants are erroneously, I would submit, submitting on the condemnation is that that's the be-all, end-all of the dedication. And they want to just disregard the other 40 years of dedication. And as this court noted in Erie, there was many indicia. They had deed restrictions in Erie, and they said that was listed among the facts as one indicia of the dedication. There are ordinances in this case recognized in the park. There was decades of long-standing public use and public monies used towards improving the park. So this case really isn't far off from Erie at all. The Erie case, I'm sorry.
Before you move on from that, I'm trying to follow you on this dedication issue. It seems to me that what Mr. Byer was arguing was if the eminent domain code requires a stated declaration of purpose, and we're reasonably viewing that declaration of purpose as satisfying the requirement of a dedication and serving as a dedication, then that's what we should be looking at as the dedication. Now, are you saying it's not a dedication, or it's partly that, but you have to look at more?
It's an indicia, in my opinion, Your Honor. It's one factor, but it doesn't take it out of it doesn't take this public park that's being used right now, as I'm arguing, and people are probably running through it right now. It doesn't take this out of the public trust context. You know, this is a public trust property that the municipality is obligated to treat as a trustee, and they don't have the unilateral ability to just make a declaration that we want to abandon this, and therefore there's no more public trust interest. It's not magical like that. So it's just one part of dedication, and that the dedication is all the years of the majority of the indicia is the 40 years of use, the 40 years of improvements. So I think it's an error to fall into the trap, like the Commonwealth Court did with the Project 70 Act restrictions, to equate these things. In Erie, what the court said was that it recognized these independent property deed restrictions that existed in Erie Golf Course, and Justice Saylor wrote and referred to them as independent interests. And that's really what we're dealing with here. And he said that they would require separate relief under property law principles. Now, what property law principles provide are the deed restrictions are treated like private contracts. And that makes perfect sense here, because the Commonwealth, the Project 70 restrictions are a private contract between the Commonwealth and the borough. The public isn't involved. And the Project 70 Act actually specifically says that we have no business. The public has no business objecting, and we have no standing to object to whatever happens with that private contract, that independent contract. And the Commonwealth Court, in kind of a puzzling move, cited the White case and the Pilcheski case, which actually, before this case, that they recognized also that these were independent property rights. Those both dealt with these kinds of contractual deed restrictions and held that even if those deed restrictions are removed, the public trust interests would still be enforced. But that's really just kind of a minor issue. Again, the main error that the Commonwealth Court made here is that they equated the dedication with the restriction. That they said the removal of the restriction voids the dedication, which just disregards 40 years of public use and improvements. And it's also, I would like to point out the terms of the Project 70 Act, as pointed out by Justice Mundy, they do not authorize any sale. They merely, the Act itself, the Project 70 Act, merely requires restrictions that cannot be disregarded, and the language is without the approval of the General Assembly. It does not authorize any sale. And similarly, the more recent acts that remove those restrictions, the language there, what it specifically says, it authorizes the release of restrictions. So that's a condition to a condition of the sale. It's just, what we're talking about here is just one step towards a sale.
So, Counsel, why isn't it an appropriate interpretation of Project 70 that the legislature dedicated this as parkland, and the legislature, within its inherent authority, revoked that dedication?
Because, Your Honor, there's no mention of any kind of dedication in the Project 70 Act. What it talks about is how the Commonwealth Court makes funds available and how it controls, how it regulates those funds. So it's a fund-based statute, and it doesn't talk about dedication. There's nothing in there suggesting that it was supposed to deal with public trust interests or anything like that. The DDPA is the legislature's law on public trust interests. So there's no statutory conflict here. If these restrictions are removed, that's fine. But there's still a requirement that the municipality has to go through and deal with the public trust interest, those independent interests, in a separate manner. So, and that's frankly, it's a constitutional matter. I know in the Robinson 2 case, it talked about one branch of government not being able to dispose of public trust interests. And really what we're asking for here is that we have court review and public participation. That's what the DDPA says, and that's a constitutional manner. Otherwise, you're stealing from the public, and you're just shutting the door on the public and saying they cannot ever object to their parks as long as some grant money from 1968 is removed. That's not what was intended. The Project 70 Act actually says that it was meant to protect parks, so it can't be used as a weapon to eliminate parks. Lastly, the issue with the easements, I wanted to point out that the DDPA has specific language in it providing that the borough is required to hold the park as trustee for the public, and the terms are with full legal title, and that any relief must serve a public purpose. Here we have clearly what is 100% a private purpose for a development, and I think Justice McCullough, in her dissent for the Commonwealth Court, got it right when she cited to the unanimous opinion that Justice Saylor again wrote in Reading Area Water Authority that held that stormwater and utility easements must have a primary public purpose. It also flows into the more recent Robinson Township case, the majority opinion from 2 months ago. And although that those cases dealt with condemnation, I think there's a common thread there where you're talking about public interests, and that therefore there have to be the public has to be the primary and paramount beneficiary. And this, even though there's different statutes involved here, those same principles are baked into the DDPA because it says it requires that the purpose be public. So that the language is already there, and we want to avoid what Justice McCullough correctly noted was an inherent conflict with private interests. I did watch some of the more recent arguments before this court, and in September there was a case called Starling versus Lake Mead Property Owners Association, and these Starlings were very possessive, aggressive people going after this common area that was next to their house. And I would submit that that's just an anecdotal example of what happens here. When you allow private parties, they have an open space easement this development will have. These homeowners in this association will have an open space easement over a public park. And when we convey the bundles, we have a full title, in the beginning and we convey some of the sticks out of that bundle of title of property rights, when we convey that over, what we're really doing is we're conveying control to the private parties, and we're going to end up with more of these starlings who are going to say, I don't want a gazebo there, I don't want a dock over here.
Okay, Mr. McHugh, we're gonna.
Okay. So that's, I think in some that we already have
We're gonna hear from Mr.
Okay.
Thank you.
Thank you.
Well, may it please the court, forgive me, I'm losing my voice. I feel like I should argue sort of. I felt cheated in my argument yesterday, but I saw Mr. Burns in the back. I was going to bring him up front. But let me get to the heart of this case.
No doubt he'd be ready.
Mr. Burns is always ready. I'm not going to repeat. I just want to give you a broader view. I've been involved in this case now for 9 years. 9 years of pro bono representation. I probably have invested about $500,000 of legal fees. And I want you to understand the issues here. The public trust doctrine is an ancient doctrine. It was highlighted in the 1915 case of Philadelphia Museums. And it clearly held public land used for public purposes can't be sold if it's still being used for public purposes. And the reason for that was because donors aren't going to donate if they donate land for public purposes and then it's sold off later. It has a very important purpose. The Ryers case, where I did the Borough Park, and I remember Mr. Byers' suggestion that, well, if the donation's after, but Ryers, the donation was in the 1890s, but the Commonwealth Court didn't get to you, held that the Dedicated and Donated Property Act applied. Now, where are we? What's going to happen if you allow these properties to be sold because they condemned them in 21 years or past, or the legislature, because someone got a state senator to insert something in this overall bill, says these properties are released? What's going to happen? You're going to lose all parkland. These municipalities are cash starved. And parkland such as this, which is actively used, Judge Platt clearly held that as public parkland, are going to disappear. And let's go back. You're not bound by your precedent. You're a policy-setting court. And that's what I want you to do here.
Well, we are certainly bound by stare decisis.
Well, to some extent, but there's no stare decisis on Project 70 funds, and there's none on the condemnation issue. There's a little bit of discussion and footnotes in Erie, and I'm familiar with Erie because we were part of the amicus team in that particular matter. But if you look at this, the Dedicated and Donated Property Act 59, it has a section, if it's practical, you can't sell it. This court in Erie seemed to suggest, well, we'll incorporate the public trust doctrine in there. It's my position that you did, but the public trust doctrine still has an independent life. And it's not by itself. And you should still consider that. Because what is happening here? First, in condemnation, there's, and we go through the language, but they're saying after 21 years, we can sell it. This is land that was for the purpose of a public park, which City Council, Borough Council, in 1978, dedicated all the condemnation lands to public park. It's being used as public park right through today. And they're saying, now we can sell it. Because 21 years passed, we don't have to worry about abandonment, and we can sell it. It's my position that you can read the condemnation statute in conjunction either with the public trust doctrine or the Dedicated and Donated Property Act. And the fact that they can now seek to sell it doesn't preclude them from having to go to Orphans Court to get approval. Because otherwise, we're done. Because most land are either purchased, parkland, through condemnation or through the public trust doctrine. Similarly, the Project 70. Now let's look at Project 70. Only half the monies are put up by the state. The other half is paid by the borough. The borough of Downingtown purchased this with Project 70 money and their own money. And then, as you saw from my brief, the testimony of Mr. Greenleaf, the former borough manager, Mr. Mineta, former council member, and others, they use this, put money in this, maintain this park for years and years and years and years. They even put a victim's memorial in the lower portions, the dedicated and donated the condemned areas, where they, in 2005. Even during the time of the hearings with Judge Platt, they had their advertisement saying, this is Kardon Park. You know, there's never any abandonment. They're still holding this out as a park in this matter. Now they're saying, if the legislature releases it, we can sell it. And you, Sam Stretton, and your clients can't object. No one can object. And the land can be sold without any public trust doctrine or dedicated and donated property act applying. And I suggest that would undercut the whole purpose of 150 years of protection of parkland. And you, as this court, have an obligation, I suggest, to go beyond just, we can argue till we're blue in the face about purchase and, in Section 6, Justice Bear and others, but you got to look at the broader picture and what's happening here. And if you do that, it makes all the sense in the world that the Project 70 funds cannot be sold. Land cannot be sold without at least going to the Orphans Court to ascertain whether or not there is it's no longer practical. And if you don't do that, it's pretty much parkland's gone.
We understand your argument regarding policy. It's compelling. Do you have any other point you'd like to make?
Yes, just one. What really has got me upset is using public lands for private developers' easements. Now, this court denied Alicott in my East County. Maybe I'm stuck with that. But that is a very, very serious issue where public land can, if this court would allow this to occur, or if the Commonwealth Court stood, if I'm a developer, I got a park across the street, like in Westchester or down in Philadelphia, Rittenhouse Square. In theory, I can use that to satisfy my open space or other requirements, even though my purpose is private. The land here where they're using the Meisel property wasn't condemnation, wasn't Project 70. It says purchased by the borough from Mr. Meisel in 1962. And they now are taking this land and putting in projects, easements, water management, open space for the developer. And they're using that for his benefit. And in 5 years, the homeowners association will own it, or at least half of it. And they're not going to be able to change that. And so public land is going to be restrained. And I would suggest that if you look at the policy, that is a decision that you ought to reconsider. Now, I don't want to get into details. Mr. McHugh is a wonderful arguer, and I promised this court I would not be redundant, but that is my pitch. Maybe it's more a jury pitch to you, but it is of essence, in my mind, of great importance, this decision, because it will really reflect what's going to happen to open space for the next 50, 60 years. And always a pleasure. Thank you.
Thank you very much, Mr. Stratton.